I'm here in California filming with 511. I read the news today. I see the Daniel defense lawsuit filed because of the Uvalde shooting. I do what any normal, sane human being would do, and that is set up a camera in my hotel room, grab my voice recorder to talk to you guys about it because number one, I'm very worried about Daniel defense, and number two, the outcome of this lawsuit could have far-reaching consequences in the firearms industry. And I think it's something that we need to talk about. Why am I worried about Daniel defense? Well, if you remember, after the Sandy Hook shooting, a lawsuit was filed against Bushmaster because they manufactured the gun that was used in that shooting. That lawsuit was unique because it utilized a loophole in the Protection of Lawful Commerce and Arms Act, the PLCAA, which was designed to protect firearms manufacturers from liability when their products were used in crimes. But the Sandy Hook family successfully argued that the marketing practices of Bushmaster were negligent. In that lawsuit, the Sandy Hook families accused Bushmaster of targeting young, at-risk males and advertising, depicting the rifle as military style for combat missions. They filed that lawsuit in Connecticut, which is where the Sandy Hook shooting occurred. The case settled for $73 million, put Bushmaster totally out of business, and Remington, and it demonstrated that firearms manufacturers could be held accountable for marketing strategies, which is exactly why this lawsuit was filed. Well, what happens in the Bushmaster case? In the Bushmaster case, the court finds that the negligent marketing claims fall outside the scope of the PLCAA. So as long as you make a negligent marketing claim, you can file suit against any gun manufacturer. So the court's decision was based on the argument that Bushmaster's marketing practices violated the Connecticut Unfair Trade Practices Act. Almost every state has an Unfair Trade Practices Act, and that's apparently what they used in this lawsuit in Connecticut. Sandy Hook families allege that Bushmaster's advertisements promoted the use of rifles in a militaristic, offensive manner, appealing to individuals predisposed to violence. The court ruled that the claims weren't protected by the PLCAA because they were based on state consumer protection laws rather than the inherent function of the firearm. This decision was pivotal because it recognized that certain marketing practices could be deemed irresponsible and outside of the protections from the PLCAA. Now, Daniel Defense faces a similar lawsuit after the Uvalde shooting. Those plaintiffs are arguing that Daniel Defense's marketing practices were irresponsible, contributed to the shooter's actions. More specifically, they're saying that Daniel Defense's marketing targeted young men with advertisements featuring militaristic imagery and militaristic slogans similar to the accusations from Bushmaster, also pointing out, I guess it was used in a Call of Duty game, a Daniel Defense gun. The Daniel Defense lawsuit was filed in Texas, the state where the shooting took place. And if the Texas courts recognize the Bushmaster court argument, Daniel Defense could be in serious trouble. Now, they don't have to, right? It's a Texas court. They don't have to honor a Connecticut court decision. However, it's going to be extremely persuasive, and you're going to see it all over the briefing. Because of that Bushmaster case, now you've got plaintiffs that are emboldened. They've seen it done before. They've seen Bushmaster put out of business, and they know that they can get courts potentially to work a pathway around the PLCAA through regular negligence allegations. In my opinion, Texas jury pool likely to be much more sympathetic towards a firearm manufacturer than Connecticut, which could influence the outcome of the case favoring Daniel Defense, but there's a lot of uncertainty there, and there's a lot on the line. Another factor, not just the jury that you're likely to draw in that jurisdiction, but the judge. And I think, again, in Texas, you're probably going to have more conservative judges. Of course, the law is the law, but, let's call a spade a spade. A more conservative judge is going to be more defendant-friendly towards a firearms manufacturing company. Why is that important? Well, that's because if I'm Daniel Defense's lawyers, one of the first things that I'm doing is filing a motion to dismiss or a motion for summary judgment based on the PLCAA, saying you can't bring this lawsuit. Who decides the outcome of summary judgment? A judge. And when you lose summary judgment, you might take an interlocutory appeal. That is, you might appeal the loss, and let's say you lose at the Court of Appeals. Interlocutory appeals, most of the time, you're just going to lose them. That's it. We won't get into that. But in any event, after you've lost summary judgment based on the judge's ruling and you've lost your appeal on that motion for summary judgment, at that point, you start worrying about just paying out a massive settlement to avoid getting your ass kicked by a jury to the tune of $200 million or some ridiculous amount of money that'll put you out of business. So it isn't just the jury, but obviously the judge is going to play a huge role in how this goes. Another thing that seriously concerns me is that the Uvalde families are using the same plaintiffs firm that was successful in the Bushmaster lawsuit, putting Bushmaster out of business, putting Remington out of business, forcing the $70 million plus settlement. Not to mention, they also filed suit in California. Now, while Daniel Defense has been sued in Texas, and as I said, I think that that's going to be a more favorable jurisdiction, the plaintiffs' lawyers know that too, so they have sued Facebook and Activision in California, where I bet they know that they're going to get much more favorable state laws, they're going to get much more favorable liberal judges, and they're going to get a much more liberal anti-gun jury pool in California than they're going to get in Texas. There's no question in my mind that the plaintiff lawyers are engaging in what's called forum shopping, and that is filing a lawsuit in wherever you think the most favorable forum is going to be. And that's another concerning issue, although now, I haven't looked at the pleadings yet, but I don't think Daniel Defense is actually named in the California petition, just the Texas lawsuit. And we all know as we sit here today that this is going to have repercussions in the way firearms are marketed in the future. Again, Call of Duty being sued because I guess a Daniel Defense rifle was in that game. Bit of inside baseball for you here. I'm not going to name the source, but I want to tell you that I have had a manufacturer or manufacturers who have told me, hey, we don't mind it when video games use our guns in their game, but we don't let them use the name because we were extremely shocked and concerned with the outcome of the Bushmaster lawsuit, and we don't want to find ourselves in the same position. Unfortunately, I think that that's a smart play. I could just see a plaintiff's lawyer wheeling out a 70-inch flat screen TV with Call of Duty, and you've got one of the characters from Call of Duty with the Daniel Defense DDM-4V7 mowing down a bunch of bad guys and being like, see, ladies and gentlemen, the jury says right there, DDM-4V7, this kid knew that this gun was lethal. He was brainwashed. You get it. Do I like Daniel Defense's odds in Texas better than Bushmaster in Connecticut? Absolutely. But at the end of the day, we've already seen a case where a court has found that a company can be held accountable for their marketing practices, which means it's been done before, which means it can definitely happen again. Pay very close attention to how this legal battle unfolds because it's going to have wide-ranging potential consequences, not just on Daniel Defense, but on the entire firearms industry. The outcome is going to shape the future of how firearms are marketed, the extent of legal protections under the PLCAA. Stay tuned. I'm going to follow that. Maybe I'll make another follow-up video about it. But at the end of the day, I think it's going to take legislative action to close up this loophole because essentially greedy plaintiffs' lawyers are getting around the PLCAA using this negligent marketing loophole. Guys, thanks a ton for watching. I hope you enjoyed this video. Stay informed, stay safe, take care.